Hello students, welcome to EPG Pathshala. I am Dr. Ankita Jain from DSPSR New Delhi. Today we are going to talk on module Industrial Disputes from paper Human Resource Management. Learning outcomes. The primary purpose of the Industrial Dispute Act 1947 is to protect organizations from all forms of disputes, irrespective of their sources, magnitude, and implications. Although the employers and the employees have irreconcilable goals, needs, and interests, the Industrial Disputes Act attempts to provide a mechanism for avoiding disputes and preserving industrial peace. The primary purpose of this act is to preserve the peace and harmony of an industrial enterprise. This act aims at ensuring better utilization of available human resources by avoiding disputes related manpower loss in the organization. It looks to preempt the employees' grievance and industrial tension from developing into full-fledged disturbances and confrontations between employers and employees in the forms of strikes or lockouts. It strives to provide a mechanism for the resolution of industrial disputes and assure industrial justice, which is an essential element of enduring industrial peace. It seeks to indicate the contingencies when strike or lockouts can be imposed lawfully. It specifies the grounds for declaring a strike or a lockout as illegal. It thus attempts to avoid illegal strikes and lockouts and the consequent disruption to work and also production and income losses. It endeavors to offer financial relief to the employees in the event of a layoff or retrenchment. It aims at encouraging and streamlining collective bargaining as a dispute resolution forum. An industrial dispute is basically a different opinion between the employer and the employees over one or more issues. Disputes are core to the industrial exercise of an organization. The primary aim of industrial relations exercises is dispute avoidance. The various aspects of industrial relations are designed with a view of restraining industrial dispute and the resultant labor unrest. Industrial disputes typically manifest in the deliberating form of strikes, lockouts, picketing, go-slows, gheraos. Hence, they require the development of appropriate strategies for prompt identification of employees' grievance and their resolution. In fact, a timely resolution of grievance can prevent them from becoming industrial dispute. Section 2K of Industrial Dispute Act 1947 defines an industrial dispute as any dispute or difference between employers and employees, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment or the terms of employment or with the conditions of labor of any person. Characteristics of industrial disputes. Based on the definition of the term industrial dispute given in the Industrial Dispute Act, its characteristics have been identified as follows. First, an industrial dispute is a collective dispute between employer and employees. The dispute between an individual employee and employer are not normally viewed as an industrial dispute except for dismissal, discharge, retrenchment, or termination of individual employee. Typically, the dispute should have been raised by a substantial number of employees. Second, the relationship existing between the parties to the industrial dispute must be that of the employer and employee or co-workers, that is, between workmen and workmen. Third, the dispute may arise out of disagreements between employers and employees over the terms of employment like wages and salary, incentives and benefits, workloads, and so on. Fourth, it could also be connected to the conditions of labor like working conditions, occupational health, and safety, so on. Fifth, The industrial dispute may even relate to non-employment cause of workmen. Causes of industrial disputes. Organizations can effectively avoid an industrial dispute only when it is able to locate the causes of the industrial relations, tensions, and disputes accurately. Generally, these causes are classified as economic and non-economic. First, demand for pay and benefits hike. Employee claim for increased pay and benefits and the employer's refusal to concede their demand often gives to an industrial dispute. Employers and employees often make mutually irreconcilable claim over the profits and wealth of the organizations. On the other hand, the rising cost of living, improved social status, and lifestyle changes often force employees to seek increase in their monetary compensation at periodic intervals. On the other hand, survival, prestige, and growth needs drive the employers to retain the major share of the profit. Second, demand for hygienic and safe working conditions. The employees' intents on good and safer working conditions may also form a ground for an industrial dispute. Specifically, the employees' demand for a proper physical environment, adherence to statutory safety measures, and workload-related issues can cause industrial dispute in an organization. Third, demand for better labor welfare and social security measure. The employees' insistence on improvement in welfare facilities such as transport, housing, education, recreation, canteen, insurance, e-commuting, and flexi-time can also cause industrial disputes. Similarly, the need for better social securities like retirement benefits, medical facilities, and compensation facilities may also act as a ground for industrial disputes. Third, demand for recognition and appreciation. Besides the primary needs like wages, incentives, benefits, health, and safety, the employees may also demand the fulfillment of social needs like recognition, self-expression, appreciation, and scope for personal achievements. When these demands are denied or delayed by the employers, it may provide a ground for industrial dispute. Fifth, demand for justice for an individual or a group of employees. Where there is a mass layoff or retrenchment of employees, it may provide reasons for the employees to develop a dispute with the employers. At times, even the disciplinary actions against individuals in the form of dismissal, discharge, demotions, and suspensions may form a ground for industrial dispute as per Section 2A of the Industrial Dispute Act 1947. Sixth, one-upmanship among the unions. One-upmanship is the practice of always keeping one step ahead of the rest, that is, friends or competitors, in their quest to prove their credibility and dependability among the employees. The unions may adopt a negative attitude towards the management deliberately. In such a situation, the union may start a dispute with the management even on silly issues just to unite their members and expand their membership base. Seventh, external interference. The system of allowing external leaders to manage the unions, like in India, also play a significant role in an industrial dispute. In such a case, union activities are influenced more by political considerations than by organizational problems. The union's stand on organizational issues are dictated mostly by the ideology and leadership of the political with which the union is affiliated. Eighth, numerous labor legislation. The government has enacted several legislations to protect the rights and interests of the workers in industrial establishments. It becomes a legal necessity for the organization to provide these facilities to their employees. Understandably, any violation of these provisions or denial of statutory facilities to the employees becomes a ground for dispute between employers and employees. Type of industrial disputes. First, interest disputes. This refers to the disputes relating to the economic interest of the employees. The interest disputes often arise at the negotiation or bargaining stage of a collective bargaining process. They may relate to wages, incentives, and other benefits of the employees. In short, an interest dispute relates to the conditions of employment of workers. Second, rights disputes. These involve disputes over the understanding, interpretation, and application of the rules and regulations which protect the rights of the employees. They may relate to the interpretation and implementation of statutory rules, company rules, collective bargaining agreements, and employment contracts. The alleged violation of these rules provides a ground for rights disputes. Outcomes of disputes. First, strikes. A strike is an important tool in the hands of the trade unions to exert pressure on the employers to achieve their demands. According to the Industrial Disputes Act 1947, a strike means a cessation of work by a body of persons employed in any industry acting in combination, or a concerted refusal, or a refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. Second, picketing. It is a form of protest by employees in which the primary intention is to prevent or dissuade the non-striking employees from attending to their work during the strike period. In this method, the striking employee assemble in front of the factory gates and attempt to persuade the non-strikers to decide against going inside the premises and thereby participate in the strike. Third, Ghirao. It is the form of protest in which employees encircle their employers or top managers at the workplace with a view to restricting their movements. The purpose of a blockade or confinement is to force the employer or managers to concede the demands of the workers. The wrongful confinement of any person is not legally tenable, and therefore Ghirao is an illegal act. Fourth, lockout. A lockout is the employer's response to the employee's continued protest in the form of strike. According to Industrial Disputes Act 1947, a lockout means the temporary closing of place of employment or the suspension of work or the refusal by an employer to continue to employ any number of persons employed by him. Types of strikes. First, general strike. It normally refers to a large-scale strike organized by the employees belonging to an industry, aggregation or an entire country. Normally the employees of the region, state or nation are united by common goals and interests and as such struggle together. Second, pen down, tools down and sit-in strike. In pen down, tools down and sit-in strikes, employees report for duty but do not work. In these forms of protest, the employees just refuse to leave their place after entering the work premises and remain idle. Third, wildcat strike. When employees resort to an unauthorized strike in violation of the labor contract or agreements, it is called wildcat strike. Unions may resort to wildcat strike to pressure their employees during negotiation. Go slow or slow down and work to rule strikes. This is a form of strike in which employees work but not up to their usual levels or capacity. They reduce their output deliberately to show their protest to the employers. Fifth, sick leave and mass leave strikes. Employees participating in these strikes apply for sick leave or casual leave in mass, mentioning sickness as the reason. The purpose of such mass, casual or sick leave is to bring the work to a halt in order to achieve their demands. Next, hunger strike. In this, employees undertake fasting by abstaining from both food and work as a means of protest. Since there is a cessation of work due to employees' participation in the fasting, it is viewed as a strike. Next, sympathy strike. The purpose of a sympathy and solidarity with another group of striking employees belonging to a different category of employment in the same organization. Prevention of industrial disputes. The following measures can be taken to avoid disputes in industries. First, model standing order. The purpose of these orders is to prescribe guidelines for regulating between employers and employees under the Industrial Employment Standing Orders Act 1946. Second, Code of Industrial Discipline. It consists of three sets of principles, namely A. Obligations to be observed by management, B. Obligations to be observed by trade unions, and C. Principles binding on both the parties. Third, grievance procedure. According to Michael Armstrong, a well-developed and properly structured grievance redressal procedure provides A. A channel of avenue by which any aggrieved employee may present his grievance. B. A procedure which ensures that there will be a systematic handling of every grievance. C. A method by which an aggrieved employee can relieve his feelings of dissatisfaction with his job working conditions or with the management. And D. A means of ensuring that there is some measures of promptness in the handling of the grievance. Fourth, collective bargaining. It is a process in which the representatives of the employer and the employees meet and attempt to negotiate a contract Governing the employer-employee union relationship. According to Jusius, collective bargaining refers to a process by which employers on one hand and representatives of employees on the other hand attempt to arrive at agreements covering the conditions under which employee will contribute and be compensated for their services. Fifth, Works Committee. It deals with matters of day-to-day functioning at the shop floor level. According to the Indian Labour Conference 1959, Works Committee are concerned with a. Conditions of work such as ventilation, lighting, temperature and sanitation including latrines and urinals. B. Amenities such as drinking water, canteens, dining rooms, medical and health services. C. Safety and accident prevention, occupational diseases and protection equipment. D. Adjustment of festivals and national holidays. E. Administration of welfare and fine funds. F. Educational and recreational activities. G. Promotion of thrift and savings. H. Implementation and review of decisions arrived in the meetings of Works Committee. Joint Management Councils. These councils were set up in 1958, consequent upon the acceptance of socialistic patterns of society. These consist of equal representatives of management and workers, not exceeding 12, at the plant level in selected industrial units. The units should employ at least 500 workers, should have a well-established and strong central organization of employees' union, and should have a record of good industrial relations. Seventh, suggestion schemes. Under this system, workers are invited and encouraged to offer suggestions for improving the working of the enterprise. A suggestion box is installed. Any worker can write his suggestion and put it into the box. Periodically, all the suggestions are scrutinized by the suggestion committee. Good suggestions are accepted for implementation and suitable rewards are given to the concerned workers. Eighth, joint consultative machinery. Service conditions in the government sector are dealt with at National Council for Central Government Employees, Departmental Councils and Regional or Office Councils. Ninth, tripartite bodies. Several tripartite bodies have been constituted at central and state levels. The Indian Labour Conference, Standing Labour Committees, Wage Boards and Industrial Committees operate at the centre. At the state levels, state labour advisory boards have been set up. All these bodies play an important role in reaching at agreements on various labour matters. 10th, Labour Welfare Officer. The Factories Act 1948 provides for the appointment of a Labour Welfare Officer in every factory employing so or more workers. The officer looks after all facilities in the factory provided for the health, safety and welfare of workers. Settlement of industrial disputes. The following approaches and measures are used for the settlement of disputes in industry. First, conciliation. It is the approach by which representatives of workers and employers are brought together before a third party with a view to persuade them to arrive at an agreement through mutual discussion between them. It involves friendly intervention of a neutral person or groups to help the parties to settle their disputes peacefully. According to the ILO, conciliation is the practice by which services of a neutral third party are used in a dispute as a means of helping the parties to reduce the extent of their differences and arrive at an amicable settlement or agreed solution. It is a process of rational and orderly discussion of difference between the parties to a dispute under the guidance of a conciliator. Second, arbitration. It is a process in which a neutral third party listens to the disputing parties, gathers information, and then takes a decision which is binding on both the parties in comparison with conciliation, which involves compromise. Arbitration is a quasi-judicial process. The conciliator simply assists the parties to come to a settlement, whereas an arbitrator listens both the parties and then give his judgment. Arbitration has many advantages. A. It is established by the parties themselves and therefore they have a greater faith in it. B. The process is relatively expeditious and result in prompt settlement of differences. C. It is informal and flexible in nature. D. It is very expensive because parties can directly present their case without a lawyer. And E. It is based on mutual consent of the parties and therefore helps in building healthy industrial relations. Arbitration suffers from several disadvantages. A. Judgment can become arbitrary when the arbitrator is incompetent or biased. B. Delay often occurs in the settlement of a dispute. And C. Too much arbitration is not a sign of healthy industrial relations. Next is adjudication. It is the ultimate legal remedy for the settlement of industrial disputes. Adjudication means intervention of legal authority appointed by the government to make a settlement which is binding on the parties. Next, courts of inquiry. The appropriate government may, by notification in the official gazette, constitute a court of inquiry for inquiring into matters appearing to be connected with or relevant to an industrial dispute. A court of inquiry may consist of one independent person or of such number of independent persons as the appropriate government may think fit. Difference between arbitration and adjudication. Arbitration is a voluntary method, while adjudication is a compulsory method. In arbitration, there can only be one or more arbitration, and in adjudication, each adjudicating body has one presiding officer only. In arbitration, arbitrator cannot appoint assessors. In adjudication, the presiding officer can appoint one or more assessors to advise him in the proceedings. In arbitration, the government may ask a third party, not bound by the arbitration agreement but concerned in the dispute, to present their case before the arbitrator. And in adjudication, only the parties to the dispute present their case before the adjudicating authority. Three-tier system of adjudication. The adjudication has three-tier system, which is as follows: Labor Court, Industrial Tribunal, and National Tribunal. So students, let's summarize what we have learned in this module. Industrial disputes take forms of strikes, giraus, lockouts, etc. Wages and allowance, bonus, personal and retrenchment, leave and hours of work, indiscipline and violence are the main causes giving rise to industrial disputes. Conciliation, conciliation officer, board of conciliation, arbitration, voluntary and compulsory, Adjudication, labor court, industrial tribunal, national tribunal are the methods used to settle industrial disputes. Thank you.